Hello and welcome to the Potomac Local News Podcast. I'm your host, founder, and publisher of PotomacLocalNews.com, Uriah Kaiser. Joining us on the podcast today is Bradley Marshall. He's a shareholder attorney at Vanderpool, Frostick Nishanian, and we're going to talk about all things you need to know about if you ever have to go into the courtroom, what you should know, your rights when you're involved with the legal system. Bradley, thanks for coming on today and talking with us.
Absolutely, Uriah. It's great to be back with you again.
So before we get going into the meat of our topic, the what you should know if you're ever in this situation, give us a little bit about your background. You're based in Manassas. You've been practicing law for many years, and truth be told, I've known you for a long time. You have the community at heart. I can attest to that. From one community news publisher to a local attorney who has the community at heart. Give us some background about yourself.
Well, thanks. I appreciate it. Thanks for those kind words, and the feeling's mutual, of course. Yeah, you've known me through my prior job as well. So let me just kind of start from what brought me to the area. I grew up in Nokesville, went to Brentsville High School, and then went on to College and University of Virginia and law school in Michigan. And then I came back to Prince William County, both summers of law school, and then eventually after law school, I took a full-time job working for Paul Ebert, who was the Commonwealth's attorney of Prince William County at the time, and retired as the most senior prosecutor in the nation with as much of his experience. I left that position. I've been practicing law since 2007. I left that position in 2020 after political change that's inherent with elected officers and prosecutors, and joined Vanderpool, Frostick Nishanian in Old Town Manassas, and started the white collar and criminal and traffic defense division. I also co-lead our investigations division, and I also work on our civil litigation and municipal law teams.
Now, you mentioned that you transferred out of the Commonwealth Attorney's Office in 2020. We saw Paul Ebert retired in 2019, and now Amy Ashworth runs that office. But under Paul Ebert, that guy ran that office from 1968 until 2019. And as you mentioned, he is one of the most accomplished public defenders, Commonwealth attorney, in the nation. In Virginia, I know my time covering, the sniper cases and many. I actually witnessed. Truth be told, I witnessed an execution when Virginia still had a death penalty, and Paul Ebert put the man there whom I witnessed the execution. I think he had more death row convictions than anyone else in Virginia, and one of the highest in the nation. But that guy he went after criminals. He was known for that. So you got to work under him and during that era. And I don't think there's anyone like that since, before or since, really, to have the reins of that office for so long. What was that like working under Paul Ebert?
Well, it's you're a little starstruck at first. He is everything you said, and in the legal world, it's even more magnified. And especially, he was nationally prominent. Kind of began with the Lorena Bobbitt case that he handled back in the 90s. Which, if you talk to him about it, there's actually some great documentaries about it where he's interviewed. He kind of talks about how that coincided with the start of the 24-hour news cycle. And that's one thing he attributes to how, viral it went. We didn't have that term then. But, and then with the sniper prosecutions in the early mid-2000s, that's where he gained really international prominence. And, there were murders committed in multiple states and then multiple counties within each state. And, the Attorney General of the United States got to pick where it was prosecuted first, and they chose Paul Ebert for all the reasons that you just stated. So to work under someone like that, to work with him, the senior staff, the chief deputies were also on that high level of experience. It was just, there was so much mentoring and teaching going on. And it just, we were very committed to community safety, but also very committed to second chances and balancing the interests of justice and mercy. And I quoted Paul Ebert in court today to a judge who also used to happen to work for Paul Ebert. And I told him that Paul Ebert taught me the two most important lessons I ever learned in this profession. And he taught them to me the first day I worked for him. And the first one was everyone deserves a second chance, but they don't necessarily deserve a third. And secondly, and candidly, he said, if you're ever, and I, young man at the time, he said, if you're ever prosecuting someone for something that you've done, consider giving them a break. And I, half jokingly looked back and said, that's going to be a lot of breaks, Paul. And he said, I know it is. It should be. And so I quoted that today, and it helped an argument for a young man's case today. So, his lessons still hold true, and his mentorship continues. I had lunch with him last month.
That is amazing. And truth be told, I sent a few questions over to Bradley before the interview, as I do with all my guests, just to get them sort of familiar with what we'll be talking about, and it just helps them prepare. That question about Paul Ebert was not on the list, and so that was a very genuine response from Bradley. So that's a great story. Thank you for sharing that. So now that you're out of the Commonwealth Attorney's Office, you've been with Vanderpool, Frostick, and Nishanian. We'll call them VFNN, as they're more colloquial known throughout the community. VFNN for many years now. We want to get into some of the things, some of those questions that were on that list that I sent over to you. You are a defense attorney, and I'm sure that you work with all walks of life. You come through your door, all different types of people who, for one reason or another, are involved with the legal system, and so many of those come in after they've been stopped by the police. They've had they first must have had an interaction with a police officer probably before they get to your door. So what's the first thing someone should do if they're pulled over or stopped by police?
Well, that's a great question. And I was even going to preface this part with, earlier you said, some tips on what to do if you end up in court. But our tips are going to start from the moment that you are stopped by the police, or what the law would call a seizure. And pulling someone over is a very low standard. It's called reasonable articulable suspicion. This is what's needed to pull you over, to talk to you on the side of the road about a potential traffic violation, to investigate further, things like that. It's a very low level thing. Let's just, for sake of argument, say it's on a scale of 0 to 100. We're talking 20% or so, just some reasonable reason to engage with someone. And then, once they pull you over, you should always stop. Okay. If you have any arguments or something about, you have a different opinion about what might have happened, and an allegation of a traffic infraction or anything else, the side of the road is not the time to argue. Okay. That's what people hire me to do. And what you're going to end up doing is making admissions that will hurt you, because you're going to apologize, which is a confession, right? And you're going to do some other things like that. And, attitude matters a lot too when we're dealing, especially with low-level traffic offenses, and don't want to get into a disrespectful situation on either side. So the first thing I would say is be polite and respectful at all times, but be firm in honoring your rights. And and sorry, I lost my video.
No, go ahead, and we'll cut that out.
You want me to go back just a little bit? And
yeah, sure, go ahead. Once you restore that video.
Sorry.
There you go.
And so in that, in that respect, we want to honor our rights, as soon as we're able to. And, I keep the Constitution on me at all times. It will be in my breast pocket over my heart when I'm in court. It stays in my folio, and I cite it a lot because this is where all of your rights begin and often end. And, these rights are there for a reason. These rights are there to protect you from the government. And, invoking your right to remain silent, invoking your right to counsel, it doesn't mean you're guilty. In fact, it can never be considered against you in determining if you're guilty. Some people think that just invoking alone means I must have something to hide. It doesn't. And it doesn't mean that you're not trying to be honest or anything else. It just means you're going to respect your rights. And while it's not the right time for you to argue on the side of the road, it's certainly not the time to engage in legal process without an attorney that could have very serious ramifications.
So it's interesting that attitude, right? When you approach something, and I think that's much like anything you approach in life. If you have the right attitude and you go about it, it could very well change the outcome of the situation that you're in, especially if you find yourself on the side of the road. And So go in more detail for me about remaining silent and why it's important to do that. I mean, there are some people who have the mindset that, I'm sure they're out there. I'm going to tell, if someone stops me, I'm going to give them a piece of my mind. I've got somewhere to go. Why are they, delaying me? You're just trying to, get in my face. You're giving me a hard time. And then you have the others who think that, if I remain silent, if I say nothing at all, I'm automatically guilty. I have
Right.
to, like you said earlier, apologize or make admissions. I have to, be remorseful on the side of the road. But you say it's important to remain silent.
I do. Rarely are you going to talk yourself out of the situation. More often than not, you talk yourself into the situation, quite frankly. And let's think about this situation from both sides. Okay, like what you just said was kind of from the motorist side, right? Like, they feel inconvenienced, or they didn't do anything wrong, whatnot. But let's think about it from the officer's side as well. I was lucky enough to do a ride along when I was a young prosecutor with Officer Chris Young, who tragically passed away later. And he taught me one of the most important and most eye-opening lessons I ever learned on that ride along. And he said, I never forget that when I'm dealing with someone, I'm probably dealing with them on the worst day of their life, or one of the worst days, because generally speaking, people are good, and they make a traffic infraction is one of the biggest mistakes they have, or an arrest or something like that. It was the worst day of their life, and they were going through a crisis or whatever it might be. And it was a really, really important lesson to learn. So I think police need to come with that grain of salt as well when they're approaching. But people need to realize that police often, it's kind of like, what you're going to get at the DMV counter, right? Because these people deal with the most angry, upset, rude, emotional people constantly, right? And this is what police officers do. But they do so, at least a huge majority do so professionally and courteously. When I was a prosecutor, and even today, of course, one reason why I think I'm an effective defense attorney is because I know exactly how the prosecution analyzes and what they're looking at, and what we can do to mitigate and remediate and do other things. And on a low-level traffic offense, as a prosecutor, you only ask 3 quick questions, right? What are they accused of? So whatever, speeding, 20 or whatever it is. What are they accused of? What's their driving record? And how were they with the police officer? Those are the 3 factors. And so for a low-level offense. And so you can very respectfully honor your rights and still be courteous to the officer and save any arguments about the facts, the law, anything else for me to do in court.
That's amazing that you bring up Chris Young, who is who is a very well respected police officer. He was tragically killed in 2011 on Route 28 in front of the Target as he was riding his motorcycle, responding to a call. Now has an elementary school named after him in Prince William County, and he actually stopped me on Old Bridge Road and gave me a ticket, and I was going. It was one side of Old Bridge was 45 and the other side is 35, and I didn't know, and I didn't know the difference. And so in the morning I would take it to 95, and I would take it home in the afternoon. So I went to court, but on the side of the road, he explained to me exactly what I did wrong. He was very candid, very nice. We certainly wasn't, and he was a gentleman, and he's the kind of police officer that you could only hope to run into if you're going to be in that situation. I went to court. Chris Young was there in court. I lost. He won. I was in the wrong. I accepted it. I moved on. I did not get an attorney when I went to court. But when should someone, if they're in a situation, when should someone ask for an attorney, and what happens after they do?
I assume you mean invoking your rights and dealing with law enforcement. Look, there are 2 separate constitutional rights, and they generally overlap. And the way that people commonly understand Miranda warnings and things may get a little bit confusing. But you have a 5th Amendment right to remain silent, and you have a 6th Amendment right to counsel. Okay, and they're separate rights, and so they have separate analysis, and there's separate triggers for them as to what triggers them. There's separate ways that you could uninvoke, so to speak. So generally speaking, first of all, you must invoke. No one can invoke for you. If you're talking to the police, you can't call me, put me on speakerphone, and I invoke for you. You must invoke. Okay. If you invoke silence and you decide to re-engage with them later and start talking, whatever you say later voluntarily outside of being questioned or anything, is going to be, admissible as evidence against you. The key is, them asking questions and you giving answers. That's when you invoke. Now, your Miranda rights, you truly are not entitled to your Miranda rights unless you are in custody and being interrogated. In custody means, generally speaking, not free to leave. And interrogation means being asked questions. And if those two conditions are met, Miranda applies. And it's very, very often that I have a consult and they say, they never read me my Miranda rights. I said, well, were you ever, not free to go? Or you weren't, and they people just assume that they must tell you these rights right up front. But they're only triggered when you're actually detained and being questioned. And so I, encourage people to invoke both their right to remain silent and their right to counsel. If you invoke your right to remain silent, as I started to say earlier, and you can revoke that later and go back in. Invoking your right to counsel is paramount. Once you do that, then the police can ask no more questions and can't do anything else. There's a time analysis on here, and it gets really complicated. There are some exceptions, but if we're talking side of the road stuff, that's absolutely the case. And so, you don't even need to directly invoke to invoke. What you can just say is, Your Honor, your officer, respectfully, I don't wish to make any statements, but here's my ID, here's anything else, And if it turns into something more serious, where I don't know, you have a warrant out you didn't know about, whatever it might be, there's something else in your car that they discover, and it leads to a more serious situation, invoke right away and just say, hey, I might be willing to talk to you about this stuff, but I got to talk to my attorney first, and go from there. But invoke early, invoke often. Don't withdraw your invocation of your rights, and just be respectful in doing it. Very often you'll hear, like in court, it's a little dramatized. He refused to do this, refused to do that. Say, Judge, he didn't refuse to do anything. He politely declined.
That's good. That's good. And while we're talking about definitions of what things are, it's and I want to get your opinion on this. In my history, detained, we have two words: detained and arrested, right? And so detained, to me, if you ask me what it is, it's a cop told you to sit on the curb while they figure out what's going on, and if you get up and walk away, they're not going to like that, and you're not going to like what's coming if you decide to get up and walk. Arrested means you're in handcuffs, right? Yeah. So is that generally about what would you agree?
Generally, that's true. Custody means not free to leave. Okay, and we analyze all these things from a hybrid of an objective perspective in the subjective shoes of someone in that situation, right? So would a normal person in that situation, normal, just rational, prudent person, feel free to leave? That's really the analysis. And if the answer is no, then they are detained. And then what rights trigger depend on interrogation, asking of questions and whatnot from there. Generally speaking, arrest equals handcuffs, but it is possible to be arrested without being put in handcuffs. For example, the issuing of a summons is technically an instant arrest and release, technically. Sometimes people get charged with something, but they get injured, so they have a DUI and a crash, and they're at the hospital. They can come serve you on a summons, and they actually have to physically touch you. That's what the law says, and you've been arrested, even though you never go in handcuffs, you never go in front of the magistrate, you never go to the jail because it's impractical.
Interesting. Well, if someone is in that situation, what should people know about searches and when to refuse consent?
Well, generally speaking, until some statutory changes in the 2020 special session of the Virginia General Assembly, where a lot of crime reform, criminal justice reform took place, historically speaking, since 1607 in Virginia, consent takes you outside of the legal analysis, right? So if you fully consent to something, you have now moved outside the Fourth Amendment, okay? Because this protects you on reasonable searches and seizures. If you consent to it, then it's so be it. So I would respectfully suggest to people to never consent to a government intrusion into your privacy. There are ways, if they have probable cause and you're in a vehicle, for example, they don't have to have a search warrant to continue looking for things. But even if they think they have probable cause, they're still going to ask you for consent, because then even if it turns out they didn't have probable cause, you consented. So it's irrelevant whether they have probable cause or not. So don't consent. And if they still have probable cause, they'll do what they think they can do, and we'll sort it out in court as to what they could actually do and not do. But I think that invoking your rights early and often is really important. And
We
I mentioned a couple statutory changes. Let me just bring one up, for example. A lot of them had to do with traffic offenses and things, but for example, now in Virginia, the police cannot search your vehicle or your person strictly on the basis of the odor of marijuana. Okay, they used to be able to, they can't anymore. And so that statute and a few others like it that deal with some other mostly traffic related stuff and equipment violations and things says, even if they consent, you still can't use it, because we're saying in this statute that consent does not override this situation. But in all other situations, it does, as long as it's voluntary. Obviously, if you're compelled or forced, that's not consent to begin with.
we've covered a lot of ground, and yeah, I'm wondering if as someone may be sitting out there listening to this, and putting all the pieces together and making sense in their mind of what we're talking about here. But I think what would be really great is if you could share, an anonymous story. Of course, we don't want to name names of anybody, but how knowing their rights made a difference in the outcome of their case. Just someone who was smart about it and went it the right way. Is there anything that comes to mind? Can you give us an example?
Yeah, I can give you several. And it's important to keep that in mind, because very often it's the critical issue in a case, and it does boggle my mind how often people don't invoke their rights, or really don't even know their rights. But yeah, I can certainly give you some examples. Very recently, let's just say very recently, I was representing someone in a different jurisdiction, and they were charged with a serious offense, And when there was a search warrant executed in their home, they were interviewed and everything, but they made no statements. And had they made really any statements, the entire nature of the case would have changed completely, because there were some gaps in the government's ability to prove certain things, and those statements would have filled it in. By honoring his rights and invoking them and standing by them, the police even at one point, did something they shouldn't have done, and said, hey, we're going to have to tear up everything here if you don't just tell us where this item is or whatnot. And he still didn't do it, and that wasn't a proper question after he invoked anyway. But it's just so important to stand true to it. And I'll give you another example. It's a high profile DUI case where I focus on Fourth, Fifth, and Sixth Amendment issues, suppression issues, we call them. And it was a case where someone shouldn't have been stopped in the first place. And then the case was dismissed because there was just no reason for the police officer to pull them over in the first place. But, one thing I want to be very clear about here is that, people think that these are loopholes and technicalities. This is the Constitution of the United States. And invoking your rights and using the Constitution to your advantage, it doesn't mean that you're helping people get away with crimes. It doesn't mean that certainly that you're encouraging any crime or anything like that, or exploring loopholes or anything like that. It just means you're holding the government accountable, which is entirely the purpose of the Bill of Rights. Entirely.
Absolutely. And this is the stuff that they don't teach you in grade school. They don't teach you this. They don't teach you a lot about economics and balancing a checkbook and maybe becoming a titan of industry and entrepreneurship. But this legal information, and as you said, holding the government accountable and knowing your rights based in that document that you have in your pocket. I think that's awesome. You keep that pocket constitution right there. That's the guy you want in court, who has that, who knows not only your rights but his own as well. That's so great. As we wrap up here, Bradley, tell us how people can find you and what jurisdictions that you will go to and what links you'll go to help someone who may need your help.
Well, happy to talk to anyone, and that's the first piece of advice I have. If you're ever in these situations, first honor your rights and then call an attorney. I do free consultations. I'm happy to talk to you about your situation. Very often I tell people, look, you don't need to hire me. Here's what you need to do to take care of this yourself. But if we come up with a constitutional issue or it's a serious case, you should consider hiring an attorney, but at least consult with them. Prince William County Bar Bar Association, for example, has a consultation service. I believe it's $35 or $40 to consult. I'll do free consult. But, as far as, when you want an attorney or not, it's just going to depend on those. But the more serious it is, obviously, the more you should consider having an attorney. And also think about collateral consequences, right? Your insurance, your DMV record. The court doesn't really impact the DMV record, but they report your convictions. And so what are the other impacts? And a huge one, if you have any immigration consequences whatsoever, you should always consult an attorney, especially right now, given a very dynamic legal state there. But you can find us at vfnlaw.com. That's VFN as in Victor, Frank, Nancy, vfnlaw.com. Our phone number is 703-369-4738. We're also on Facebook and LinkedIn and all kinds of other social media. So you find us anywhere there. I go basically anywhere depending on the case. I have a little hashtag that you're aware of that it's an old Western called "Have Gun Will Travel." So I say "Have Bar Card Will Travel." And I basically draw my jurisdiction at Interstate 64 and north, but I do cases in Charlottesville, down in the Valley, in the Roanoke, Eastern Shore, Norfolk. So it just depends on the case. But if I can't help you, I will connect you with someone who can. So feel free to start with me.
Again, Bradley Marshall is with Vanderpool, Frostick Nishanian, PC. That website again is vfnlaw.com. Bradley, thank you so much for coming on today and educating us on our God-given rights here on the Potomac Local News Podcast.